Hello and welcome back. This is your second of two videos about the federal judicial system. In this one, we're going to go through a bit of the organization about the way the federal court system was put together, and we'll talk about the district courts, the circuit courts of appeal, the Supreme Court, some of the things the Supreme Court does, and where judicial review came from. The story of the case of Marbury versus Madison and a couple of other matters, including ways in which some people have suggested we should change the federal judicial system to make it work better. So, quick history. Won't go into this in a lot of detail, but understand, remember we talked about how the first Congress convened under the new Constitution in March of 1789, and the first bill they introduced in the Senate turned into what became the Judiciary Act of 1789. What's the point? The point is the Constitution only created the Supreme Court, and then it left it to Congress to set up the rest of the courts. And it's one of the first things they did. And that was the foundation for the current three-level or three-tier system that we have. Now, they did it differently back then. There were 13 judicial districts. There were 13 states, 13 judicial districts. They had their own trial courts. They had a 6-person Supreme Court. Now, today it has 9, and most people think the Constitution requires that, but it doesn't. The Supreme Court can be any size the Congress wants it to be. It can be 3 justices. It can be 30. It's up to Congress. And then they had the intermediate appellate courts where they didn't really exist as separate courts staffed by separate appellate court judges, which they do today, but back then they didn't. Each appellate court was 1 trial court judge and 2 Supreme Court justices, and that was called riding circuit. They'd put the Supreme Court justices in a cart, and they'd have to ride around, for days at a time to handle these appellate court decisions, and they hated it. So then in this act, as I said earlier, was a compromise. I mean, there was a lot of disagreement about the way to set up the federal judiciary. Why? Because a lot of state rights advocates were afraid of the power of the U.S. Supreme Court and of federal courts generally. So what they did, essentially, was they said, well, every district court will be drawn along state lines, which is still true, except that some states have more than 1 district. But no district can cross state lines. I'll show you a map in a minute. You'll see what I mean. The district court judges under this act would have to be residents of their states and districts. And as you know, the subject matter of the federal jurisdiction was limited, so they wouldn't wipe out the state courts. So we had this compromise in 1789. The Federalists wanted another Judiciary Act of 1801 to expand the powers of the federal courts. They wanted, to eliminate circuit riding and all that sort of thing, create new judgeships. And then there was a massive controversy about this after Thomas Jefferson was elected in the election of 1800. A very, very significant election that we will talk about when we talk about elections. But it was a controversial election in which the Federalists were wiped out completely, and a new party, the Jeffersonian Republican Democrats, became the party that ran Washington. And at that point, they wanted to get rid of all these federal judges that had been put in place by the Federalists. They really, the Federalists were the last bastion of the Federalist power was the federal judiciary. And so when Congress and the presidency got taken over by the Republican Democrats, or Democrat Republicans, the Jeffersonians, let's call them, they went to war with the judicial branch, and that type of controversy we still see around us today, where we have a president and Congress of one party, maybe, and then the courts taking a different position because they're appointed by a different party. So, as I said, they're a political branch, but their political influence is limited by the fact that they are courts and they have to follow law. So, from throughout the 1800s, basically, there were all kinds of efforts to change the courts in certain ways. They eventually did away with circuit riding, which was very, very hard for the judges to do when they got old, especially. There were a lot more cases because of industrialization after the Civil War, especially. And then there was the issue of judicial review, that is, the courts taking on the question of deciding on the constitutionality of legislation. At the end of this video, I'm going to explain to you where that came from. So because of all this extra business that the courts had, finally Congress in 1891 passed the Court of Appeals Act of 1891, and that's when they created the permanent, separately staffed, independent courts of appeal, a mid-level between the district courts, which are the trial courts, and the U.S. Supreme Court, a level of appellate courts that is judges who are just appellate court judges. They're not district court, they're not Supreme Court, they just do one thing. It was really an important thing to do, and they created circuits. Originally there were 9, but as you'll see when I show you the map, there are more than that now. So now the Supreme Court didn't have to hear all the appeals, only the ones they thought were really important. And they got control over their own workload, the Supreme Court did. And that's the basic structure that we have today. It's been in place since 1891. It kind of looks like this. Don't get intimidated by this. This is, I made reference to the term Article 3 judges and Article 1 judges. Article 3 meaning they are the ones that were authorized under Article 3 of the Constitution. Article 1 judges, that's the bottom level where it says federal courts and boards outside the judicial branch. These are courts that were just created by Congress for special purposes. The military, taxation, tax courts, veterans claims, those are special courts. I just understand they exist. I don't expect you to memorize this. What I want you to know is the trial courts are called the U.S. District Courts. The appellate courts are the U.S. Circuit Courts of Appeal. And there are 12 circuits, and then there's the United States Supreme Court, and this is the way the system is organized. Now, let's look at the districts and the circuits, and that's what you see here. If you look closely at this, you can see that we have 11 circuits, and the 12th is the D.C. Circuit. There's also something called the Federal Circuit. Now, that's a special appellate court that handles only a very special type of cases. But there are 12 geographical circuits. You can see the numbers. We are in, if you look closely, we are in the 7th Circuit. So all appeals from Illinois, Wisconsin, and Indiana district courts go to where the 7th Circuit Court of Appeals. The district court for this district of Illinois is in the Dirksen Building in downtown Chicago at Jackson and Dearborn. And the 7th Circuit Court of Appeals is also in the very same building. It's in Chicago as well. Now, if you look closely at these states, you can see most of the states have only one district. That is Montana. That's a district. There's a Montana district. But now let's look at California. You see those little dotted lines? You see there are 4 separate districts in California. That's just because there's so much business. So there are 4 districts, and in Illinois, if you look very closely, you can see we have 3. A northern district, which is where we are, a central district, and a southern district. So there are separate courthouses for the federal government, the federal district courts, in all 3 of those districts. So we have 3 districts. No, look around. Alabama has 1, Arizona has 1, Washington State has 2, etc. Missouri has 2, etc. So some states have more than 1 district. And that becomes significant because not only does each district have a court, a district court or a set of trial courts, it also has its own U.S. attorney. So each district has its own attorney. So Article 3 versus Article 1, look, it's very simple. Article 3, they have the full judicial power that we talked about in the first video. They have the power given to the federal courts in Article 3, nominated by the President, confirmed by the Senate, life terms. That's all district court judges, all circuit court of appeal judges, and all justices of the U.S. Supreme Court. They can handle all diversity cases and all federal question cases. Article 1 judges were created by Congress. They don't have the full power of Article 3. They only have whatever power Congress gave them. Why do we call them Article 1 judges? Because remember where Congress gets its power? Article 1 of the Constitution. So Congress set up courts because they needed them. We needed them for special purposes, like tax court. We don't want all our tax cases going to the trial courts or the district courts and the we don't. That's too much work and it's too specialized. It's too hard for judges to follow. Same thing for military appeals and this sort of thing. So these Article 1 courts are for special purposes. They can't do all these things that the basic federal courts do. So now let's go through these courts one at a time. District courts, those are the ones I just showed you, the districts. 3 districts in Illinois, northern, central, and southern. These are the trial courts, the workhorse courts of the federal system. There are 94 districts in the country. And there's at least 1 district in each state, as I showed you. And there is no district that crosses a state line. A district has to be completely contained within a state. As I said, there can be 2 or 3 or 4 districts in that state, but you can't have a district that is like part in Illinois and part of it is in Wisconsin. Can't be, not allowed. No district can cross state lines. And then, they can divide it up. There can be districts and divisions and whatnot. There can be many judges, literally several courthouses within a district. That's okay, but it's all one district. There are 673 of these district court judges. As I said, very important to know this, nominated by the president, confirmed by the Senate, serving for life if they want to, until they want to retire. The number in each district depends on the workload. It's determined ultimately by Congress. And of course, they have a big staff of clerks and administrative assistants and so forth. But as I said, also in each district, every district has its own federal prosecutor, its own U.S. Attorney's Office. Again, nominated by the president, confirmed by the Senate, but can be fired by the president. Unlike the judges, who can serve, the president can't get rid of them. The U.S. Attorney, they can. And they prosecute violations of federal law, and they also represent the government in civil cases. Now, in addition to the full district court judges, they have helper judges. We call them magistrate judges. They are selected by the district court judges. They serve 8-year terms, most of them. They can be removed if there's a reason. There are 541 of them and 32 part-time ones. And what do? Well, they do a lot of the grunt work, so to speak, for the full district court judges, so the district court judges don't have to do it. For example, the preliminary stages of criminal cases like arraignments and this sort of thing, the charging, not the trials, unless all the parties agree. They can only conduct a trial if the parties to the case agree that they can. But they do the beginning stages of criminal cases. If someone's charged with a misdemeanor, a minor crime, not a major crime, they might be able to sentence them. In civil cases, where people suing corporations and that sort of thing, they handle the exchange of information that's called discovery. So they do the preliminary stages of cases so that the district court judges don't have to. Also in the trial courts, we have bankruptcy. These are all, the district courts don't have to do bankruptcy because we have special bankruptcy judges. There's one bankruptcy court in every single district. So in the Northern District of Illinois, where we are, there's also a bankruptcy court. And I won't expect you to learn all about bankruptcy, but understand these judges only hear bankruptcy cases and nothing else. And there's different types of bankruptcy. This is when people discharge their debts because they can't pay them. Most of the time, bankruptcy involves either Chapter 7 or Chapter 11, or Chapter 13. Chapter 7 is basically called a liquidation. That is where a person's debts, they basically hand all their assets over to a bankruptcy judge. The judge gives the creditors a percentage of what they're owed, maybe a very small percentage of what they're owed, and the person who owes the money is then free of all those debts for 7 years. It's a way of avoiding being crushed by debt for life. You can actually discharge your debts without having to pay them off. Chapter 11 and 13 involve people going bankrupt but not liquidating all their assets, and instead they basically work out with the court a plan to pay off their creditors as much as they can within reason, according to the judge, and then they get a new start. So this is a kind of, bankruptcy is about a sort of debt forgiveness, a system that we have regulated by bankruptcy courts, which are entirely federal courts. Now, you don't have to memorize this, but I just want you to get a sense for the scope. This is a detailed study that was done of the caseload of the federal courts. On the trial court level, you can see that there are each year something, the caseload has actually increased from the 90s to the present. Each year there's another if we go by 2018, 350,000 cases were filed, and about 340,000 cases were disposed of. So you end up with a standing caseload in the federal courts nationwide of about 450,000 cases that they're handling. Seems like a lot, right? Well, there are many, many millions. If you add up the 50 states, millions upon millions of cases that have been filed. So the federal courts have fewer than 500,000. That's a lot, but it's not anywhere near what the states do. Now, in this case, this is civil, and you can see, if you look, we just looked at the total number, you can see that most of the cases are civil. There's 370,000 of these pending cases are civil cases. And this is the criminal, so you can see it's about maybe 3/4 of the federal government's court's caseload is civil, and about 1/4 is criminal. Most criminal lawsuits, again, are state-level courts. But each year, there'll be another 70,000 civil cases filed and probably 65,000 disposed of. Bankruptcy, look at the numbers. Look at the numbers, it's astounding. 773,000 bankruptcy cases filed in 2018. That's more than all the civil and criminal combined. You see why they created federal courts, special bankruptcy courts to handle this? Otherwise, this would all have to be in the district courts. Now, let me ask you to look back. Look down there to 2005. You see how many were filed in that year? Almost 1.8 million bankruptcies were filed in 2005. Now, why did the numbers drop from 1.8 million? Now we're down to fewer than 800,000 bankruptcies filed per year. And that is because Congress passed a Bankruptcy Reform Act. Back in the late 2000s, bankruptcy law was reformed under former President Bush. Reformed meaning they made it harder for ordinary people to go bankrupt. This is a law that corporations, collection agencies loved because it meant that people like us can't discharge their debts in bankruptcy as easily as we used to be able to. So it made it good for people like banks, mortgage companies, credit card companies, and so forth. They loved it. But people who owed money to them don't like it so much because we're forced to pay it back. Now, let's go from the trial courts, which we just covered, and the different kinds of courts at the trial court level, to the appellate court level. Now, recall they were created in 1891 to reduce the workload of the Supreme Court that was running around riding circuit, right? 13 courts of appeal, that is total. There were 11 for the states, 1 for the D.C. Circuit, and 1 for the Federal Circuit. Remember that map I showed you? There are 179 of them, appellate court judges. Again, same thing, nominated by the president, confirmed by the Senate, served during good behavior, right? And they have their staff. As you will see, the number on each circuit varies, but each one of these appellate court justices has 3 law clerks and a big staff. Normally, each case is decided by a 3-judge panel. So this is to make sure that you catch mistakes that were made by the trial court judge. So instead of having, one trial court judge makes a decision, someone loses the case, like a criminal is convicted, the criminal appeals, the criminal defendant appeals. 3 judges have to review the work of the trial court judge to try to make sure that that all the errors are corrected if they can be. And it only takes 2 of them to decide a case. So, if you have a disagreement 2-1, then the side that gets 2 is the winner. So here's that map again. Here are the circuits. Just to keep in mind the circuits. As you can see, look at the size of the 9th Circuit. And this is kind of an interesting problem. They created these circuits, remember, a long time ago, back in the 1890s. Okay, well, the population of this country has shifted. There weren't all that many people living out west a long time ago, and now there are. And so it made sense a long time ago to put all those states in the 9th Circuit, but it doesn't make any more sense because there's a lot of people living out there. There's a lot of talk about splitting the 9th Circuit, but so far it hasn't been done. So what they do instead is they take more judges. Now, so these are the circuits. These are the circuits, and as you can see, you've got, if we just take, these are the ones that have states, they're divided by states. We have 6 in the 1st Circuit. Ours, the 7th, has 11. Look at the 9th Circuit, 29 justices. That's how much work they have to do. So that's how they break them down. The caseload of the U.S. Courts of Appeals, well, it is appellate, almost entirely appellate, that is appeals. 90% of them are civil and criminal cases appealed from the district courts. That's their job. That's what they're there for. They sometimes hear appeals from administrative agencies like the Securities Exchange Commission, the National Labor Relations Board. And even though people know very little about the Courts of Appeal, the truth is they are the end of the line, the final decision for virtually all federal cases that are appealed. Federal cases either are never appealed and the trial court has the final word, the district court, or they are appealed to the intermediate circuit courts of appeal, the middle level, and they're decided once and for all, and that's that. Because as you will see when we get to the Supreme Court in just a second, the Supreme Court gets to decide what cases they want to hear. The lower courts have to take every case that is filed or appealed, but the U.S. Supreme Court doesn't. So let's talk about them. The U.S. Supreme Court is one for the whole country, 9 justices, 1 Chief Justice, 8 Associate Justices. Now, can the Congress make it bigger or smaller? Oh, yes, they can, and they have. The Supreme Court has been as low as 6 and as high as 11. And so when people say it would be an outrage to raise the number of justices in the Supreme Court, I say, nonsense. It's been done before. Okay? There's nothing special about the number 9. You can make it bigger if they want to. The cases come through a writ, what's called a writ of certiorari. Now, what I really want you to understand, I'm going to show you what they do, is that a couple of key points. First, there are only 2 ways to get to the Supreme Court. And the second point I want to make is the Supreme Court only hears the cases they want to hear, unlike the other courts that take whatever is brought to them. The 2 paths to the U.S. Supreme Court, there's a state path and a federal path. In the yellow rectangles, that's the federal path. Path is a case is filed in the U.S. district courts. That's the original jurisdiction, trial court. Someone loses. It is appealed to the U.S. Circuit Courts of Appeal, the ones we just talked about, right? The loser from there then tries to get to the U.S. Supreme Court, which will only happen if the Supreme Court wants to hear it. But understand, so we go district court, Circuit Courts of Appeal, Supreme Court. That's one path. Here's the other path, which is the state path. A case is filed in the state courts, a state trial court, like in the state of Illinois, our trial courts are called circuit courts. But it doesn't matter, it's the state trial courts. And then you appeal to the intermediate appellate courts in that state, the state courts. Then you appeal to your state Supreme Court, and you lose there. And then you petition the U.S. Supreme Court to take your case. So you have everything the Supreme Court hears, with some very, very rare exceptions, will come directly to them from an intermediate U.S. Circuit Court of Appeal or the Illinois Supreme Court, the Texas Supreme Court, the California Supreme Court, etc. State Supreme Courts and U.S. Courts of Appeal. That's where they get their business from. Now, again, 1 Chief Justice, 8 Associate Justices. The way it breaks down is 65%, about 2/3 of their cases come from the federal court route, and about 30 to 35% from the state route court. The other 5%, if you say 65-30, is the very limited number of original jurisdiction cases that they handle. Here's an example of original jurisdiction. They handle cases where the states sue each other. That's one of the rare things that they do. So the state of Illinois has been sued by the other states that border the Great Lakes because they claim that the state of Illinois is doing a bad job of protecting the Great Lakes from the Asian carp, which is a type of fish that is now in the Mississippi River and then the Illinois River and is trying to get into Lake Michigan. These are big, big, big fish that could potentially destroy the Great Lakes as a habitat because they are bottom feeders. They churn up the bottom, eat the algae. That's the bottom of the food chain. If they get in, they have no natural predators. They spread through the Great Lakes. They could destroy the fisheries of the Great Lakes. That's the concern. So we have been sued by the other states on the Great Lakes to try to make the state of Illinois take stronger steps, such as shutting down the Illinois River, the canal system that feeds into the Great Lakes potentially. Well, that's a long story, but the point is, when one state sues another, the Supreme Court can handle that. So you've got 65% of their cases coming to them from the federal courts, 30% from the state courts, and a small percentage of these states suing each other and a few other types of unusual cases. Now, here's how much work they do. Every year, 8,000 petitions come their way from litigants who want to have their case decided by the U.S. Supreme Court. They take fewer than 80. So, there you go. Your chance of getting heard by the Supreme Court is maybe 1 in 100. So when people say, I'm taking my case to the Supreme Court, you can tell them you got 1 chance in 100, because they won't take it. The Supreme Court decides what they want to decide. The Supreme Court sets their own agenda. It is a very powerful court. As of 2022, following the end of the Trump administration, the Supreme Court of 9 people consisted of the following individuals. And of course, they do a photo every year. If anyone changes, they take a new photo. But let's just start with at the end. This is the way it stood at the end of the Trump administration. The back row, we see the Justices Kavanaugh, from left to right, Kavanaugh, Justice Kagan, Justice Gorsuch, and Justice Barrett. Now, Kavanaugh, Gorsuch, and Barrett were all appointed by Trump. So that's the 3 Trump justices, Kavanaugh, Gorsuch, and Barrett. In the front row, or bottom row, you see on the left Justice Alito, Justice Clarence Thomas, who is only the 2nd African-American justice who's ever been on the Supreme Court. In the center is Chief Justice Roberts, and then seated to his right are Justice Breyer and Justice Sotomayor. Let's talk about who their party is and who appointed them. The Republicans, there are 6. Gorsuch, Kavanaugh, Barrett, Thomas, Alito, and Chief Justice Roberts, all Republicans. There are only 3 Democrats on the court as of the end of the Trump administration, and those are Sotomayor, Kagan, and Barrett. And Breyer, Sotomayor, Kagan, and Breyer are the Democrats. Now, again, you can also see here who appointed them. There's Trump. In only 4 years in office, he appointed 3. Gorsuch, Kavanaugh, and Barrett. Obama has 2 on the court, Sotomayor and Kagan. George Bush 43, the one who was elected in the 2000 election, appointed Roberts, Chief Justice Roberts, and Samuel Alito. There's still 1 Clinton judge left from the 90s. That's Justice Breyer, as of the end of the Trump administration. There was still 1. And it goes back as far as Bush 41, the president who was elected in 1988, the original George Bush. He appointed Clarence Thomas, who is still on the court. So we have a 6-3 Republican majority on the court. Now let's talk about their important role, because now we're in the realm of politics. We have acknowledged that there's partisanship on the court, that they're not all the same. They don't do things the same way. They can claim, or they can even try sincerely to be objective about things and apply the law, but they reach different decisions on the same kinds of matters. They disagree with each other. The Democrats and Republicans don't see eye to eye on certain issues. They have different values, and judges' values really do make a difference. Where does that come out? In the exercise of judicial review, which is the power of the federal courts to declare a law or an action by an executive official unconstitutional. Now, this is not mentioned in the U.S. Constitution anywhere. Most scholars believe that it was generally understood at the time that the Supreme Court would use the Supremacy Clause, which is right in there in the Constitution, to exercise judicial review over the acts of state legislatures. In other words, it was anticipated that state legislatures might do things that violated the Constitution, and when they did, they figured, well, the Supreme Court will use the Supremacy Clause, which says federal law is supreme if it is valid. But they didn't anticipate that the Supreme Court was going to be declaring laws passed by Congress and the president unconstitutional, because they thought, well, wait a minute, they're equal branches. So how can the Supreme Court strike down the acts of Congress if they're co-equal branches of the same government? And so that is controversial, and I'll show you how that came about. But understand the areas where the Supreme Court currently makes policies and affects our lives, your life, my life, everyone's life. First, questions of who can do what in the government, questions of presidential and congressional power, a lot of them, really important ones. Like, for example, if Congress wants information from the president and the president says no, I have executive privilege, I don't have to give that to you, who would decide that matter? The courts, usually the Supreme Court, but ultimately, the courts. Civil liberties, the rights of people to exercise their religious beliefs or to maybe impose them on others. Abortion, the rights of same-sex couples to marry, and I could go on, but many, many important matters. Civil rights, questions of affirmative action in education and employment, in housing, the right to vote. The Supreme Court has decided many important cases involving the right to vote, regulation of our elections. They decided who won the election of the president in the year 2000 election. Criminal justice, whether someone will be executed or not. The scope of lawful search and seizure, etc. And many, many, many other matters. The powers of the states versus the national government in our system. All these things are before the Supreme Court year after year after year. So they make very, very important decisions. Now, where did this judicial review come from? I'll tell you a story. It was created, the Supreme Court created the doctrine of judicial review in 1803 in the case of Marbury versus Madison. James Madison was the Secretary of State under President Thomas Jefferson. Jefferson was elected in the election of 1800, took office in March 1801, and got into this controversy with James Marbury, that gentleman there on the left who was a banker. So let's talk about how the story went. In the election of 1800, the Federalists lost everything except the courts. Remember those lifetime appointments? All those judges they'd appointed got to keep their jobs, but they lost Congress and they lost the presidency. And in come the Democrat Republicans. So the lame duck Federalist Congress, which remember back in those days, the election was November, but they didn't take office, the winners didn't take office for 5 months, till March. Now we wait till January. Well, back then it was 5 months. So they're called lame ducks, but these Federalists who had lost their jobs but still had power for a few months decided to create a whole bunch of new judges and stack them with Federalists. A group of them, they created so many judgeships and had so much work that the Secretary of State at that time, I'll tell you who he was in just a minute, but that was his job to deliver the commissions for President John Adams, who had lost his job, and that Secretary of State was going to lose his job soon too. And so that Secretary of State, was supposed to deliver these judicial commissions. Well, he just didn't get it done. He didn't get them all delivered by midnight. Midnight on the last day of their power, he didn't have them all delivered. Just didn't get it done. And so at that point, Thomas Jefferson, who is now taken over as president, said, don't deliver another commission. Stop it right now. If they haven't gotten their commission handed to them, they're not going to be judges. I'm going to fill those spots with people loyal to me. One of the people who didn't get his commission delivered in time, even though it was all filled out and everything else, he just didn't get it delivered, was Marbury, James Marbury. So he sued for what's called a writ of mandamus, an order from the court making Madison, the new Secretary of State, give him his commission. And because of a provision of the Judiciary Act of 1789, he filed his case directly in the U.S. Supreme Court without going through the lower courts at all. There's a problem. You probably see that. Original jurisdiction versus appellate jurisdiction, right? Well, basically the problem was this. Here's Justice John Marshall. He's the very powerful Chief Justice of the U.S. Supreme Court, as John Marshall, a staunch Federalist. He says, well, if I rule that Marbury has to get his commission, If I say, all right, I hereby order James Madison, Jefferson's Secretary of State, give Marbury his commission. He's a loyal Federalist. Give him his commission. Jefferson will tell Madison, no, don't give it to him. And Madison won't do it. And then everyone will think, well, wait a minute, we have a court and they make orders, but nobody has to obey them. They don't really have the power to enforce their orders, do they? And that would be true, wouldn't it? So Marshall says to himself, well, if I do this, it's not going to work. If I order, give Marbury his commission, it's not going to work. He's never going to get the commission, and we're going to look like idiots. On the other hand, if I rule for Madison, meaning ruling in favor of Jefferson, then I will be giving a victory to the Jefferson administration. So either way, it looks like Jefferson's going to win, and the Federalists are going to lose, unless there's a way to win by losing. And that is what Marshall did. He sacrificed Marbury, but he created a new doctrine. He ruled that, and the whole court ruled unanimously, that Marbury was entitled to his commission. He should have it. And he should get a writ of mandamus, but unfortunately, he went to the wrong court. They said, well, we'd like to give him a writ of mandamus, but we can't. And the section of the Judiciary Act at 1789 that says we can issue a writ of mandamus, I'm sorry, but that's unconstitutional. So they declared a provision of the Judiciary Act of 1789 unconstitutional on the grounds that it attempted to change the words of the Constitution, which it couldn't do. And in the process, they said, oh, and by the way, we have the power to do what we just did, to strike down an act of Congress, a provision of it, because, well, we just have that power. And that's the power we call judicial review. So basically, the court gave itself, this Federalist-dominated court, gave itself the power of judicial review that is not mentioned anywhere in the Constitution. And there was nothing Jefferson could do about it. Because basically the court was saying, we're going to enforce the decision ourselves. We're not going to handle any more writs of mandamus. Now, let me ask you this. Who do you suppose was the Secretary of State for John Adams? Who was this person who started the whole problem by failing to deliver Marbury his commission in time before the Adams administration expired? And the answer to that is, who was Adams' Secretary of State? It was John Marshall. Because his job, his gig, before he became Chief Justice of the U.S. Supreme Court he was the Secretary of State. He himself was one of the midnight appointments to the Supreme Court as Chief Justice. And he had his brother, who was the guy who was literally running around town with the commissions, and somehow his brother and John Marshall did not get the commission delivered in time. He's the person who failed to deliver the commission. And yet, if you read the entire opinion of Marbury versus Madison, which is written by Marshall, he never mentions anywhere that it was his fault that the commission didn't get delivered. So, when people suggest that the court should be above politics, you know what? You could just keep in mind the story of Marbury versus Madison. Is this a case that is free of politics? Of course not. It's one of the most intensely political decisions and one of the most important decisions in the history of the Supreme Court, and it's all about party politics. So now we're going to wrap this up pretty quickly here by talking about what the caseload of the Supreme Court is. I said they make their own decisions. Here's how they decide. They make their own decisions about which cases to take. They use the rule of 4. There are 9 of them. If 4 of them want to hear a case, it goes right on the docket and they decide it. And another rule I'm going to show you called Rule 10. So they're taking maybe 80. A few years they've gone up to 100, but normally it'll be fewer than 80 cases per year. All important questions of federal law. All cases where the lower courts disagree. And I will show you the rule. This is the rule they apply in addition to the rule of 4, Rule 10, where they basically say, they're telling everyone, this is a matter of judicial discretion. We only hear cases where 2 appellate courts disagree, where a state appeals court disagrees with another, a state Supreme Court disagrees with another state Supreme Court, or a state Supreme Court disagrees with another federal appellate court. or a brand new question, an important question of federal law that has not been yet decided. So you can read this over at your leisure, but that's Rule 10. The point of the whole thing is it gives the Supreme Court the power to hear only the cases they want to hear. And the exception to that would be the original jurisdiction, where they're hearing a case where one state sued another. But other than that, the original jurisdiction cases, they only hear the cases they want to hear. They set their own agenda, just like any other political branch. This just kind of shows you how their caseload has shrunk. I mean, they've gone as low. If you went back to, the late 1800s, they were hearing, 300 cases a year. It's gone down, down, down gradually over time. Maybe they'll hear 70 or 80. Of course, they can change that anytime they want and hear more or fewer, but they hear fewer than they used to. Last point I'm going to make to you is there are suggestions floating around Congress and the public policy arena generally for changing things. One of the most important reforms that's been suggested is maybe we should add justices to the Supreme Court. These people have such enormous influence, and they can stay on the bench for 30 years. I mean, Clarence Thomas has been on the bench since 1992. So that is, I think you would agree, a very long time. For people to be on the court for 30 years or even more than 30 years, to wield that kind of unchecked power with no one who can overrule them for decades, maybe we need a bigger court. Maybe we need more people on it. And maybe we need to limit their terms. That would require probably amending the Constitution. Maybe certain types of cases should be taken away from the Supreme Court and given to some other court, specialized court, like, for example, elections. Maybe that supervising elections is too much for them. Supervising election law is too much for them. Maybe that should be taken away. Oh, who knows? I mean, these are suggestions that have been proposed. Maybe we should have an inspector general to investigate them. When the Supreme Court in particular has conflicts of interest, there's no one who can disqualify them from hearing a case on grounds of conflict of interest. The Supreme Court makes its own decisions on that. Maybe there should be more disciplinary measures for conflicts of interest and misbehavior of various types. Maybe they shouldn't serve lifetime appointments. Maybe they should serve 20 years, 10 years, 15 years. Maybe there should be more impeachments of judges, because they have been impeached. Some justices have been impeached. But maybe there should be more of that. Maybe some courts should be eliminated. Maybe the funding should be reduced. There are many people, or maybe it should be increased. Maybe they should have more business, more judges, and more money. So the point is, a lot of this would be within the hands of Congress, and Congress could change and reform some of these policies if they wanted to. Other things, such as probably changing the terms of courts, of judges in office, that would almost certainly require amending the Constitution, which you recall is very, very hard to do. But there is an ongoing debate in our society that maybe the federal courts have too much power over our lives, and it's an interesting thing to discuss. You could take either part of that debate. Maybe you think they do, maybe you think they don't, but it certainly is an ongoing debate, and one that is worth having. So that concludes our presentation on the federal judiciary.